So are you ready to pass your real estate exam? I bet you are. You better be studying every day for at least an hour. Oops, sorry about that. I've got YouTube on, so it has a little bit delay. So I hope you're preparing for the real estate exam by studying national and your particular state questions. Here, since I'm in San Antonio, Texas, we will be doing national, will applies to all 50 states. And at the end, we will do some Texas state questions. And I beg you to also study vocabulary, vocabulary, and more vocabulary. I point out the vocabulary during the questions so that you realize how many questions are you doing. Okay, so just a little note. When you go to take the real estate exam, these real estate prep books recommend that you skip the first 5 questions by flagging them to come back to them later, because a lot of times they're the hardest and you get really nervous and you might screw up and get them wrong. So skip the first 5 and then start all the rest. Go through all the questions. You have about a minute, minute and a half per question to make sure you get them all and have time to go back and review them. Answer all the ones that you know quickly. Guess at the ones that you don't know. Flag the ones that you don't know at all. And then go back and review the ones that you did not answer. Some of the future questions will help you answer some of the prior questions that you didn't know. That's the only time that I would say go and correct and change an answer. Otherwise, don't change your answers. Okay, so we're continuing from last session, and I'm going to show you the book that I'm using and continuing with. This is the Texas Real Estate License Exam Prep, the Blue Book, which most of my students call it, and many other students, the Blue Book. And this is by Stephen Metling, David Cusick, Ryan Metling, father and son, and Dan Hamilton. I have permission to use this book on YouTube, so there's no copyright issues. And there's a link in the description should you wish to purchase the book and follow along with me, or follow along after you are watching other videos, because I go consecutively. Not every class do I do the next session. I may do a different type of video, concepts, vocabulary, but I have them on different playlists. Okay, some that are called the exam live video. So all videos that I've done live are under there. Then there are Texas videos, national videos, combination of national and Texas, and other videos that are just vocabulary and different content. So make sure you review all the different playlists that I have and utilize the ones that you need. And also on my Facebook group, which I changed to Lillie Handy Agent Prep Facebook group, is now a public group. I have a lot of guides in there that you can use to prepare for the exam. There's one called the Night Before the Exam Cheat Sheet and other cheat sheets. So use those resources on the Facebook group. Okay, so we're going to continue where we left off last week. And in the description, I put on there the questions that we're reviewing today, and for national and for Texas. So we're starting with we're continuing with chapter 2 in national. Which has to do with encumbrances, and we'll actually get into test number 3, which will then be on land use, legal descriptions, and contracts. And that's for national contracts, not Texas contracts. Okie dokie. Let's get going. And I'm going to ask you, I love to acknowledge you. So whoever is here, type in the chat, what your name is, where you're from, so that I can acknowledge you. I like to interact with you during the live and ask you to participate, answer the question, type the question number and the letter answer. Okay, here we go. So we're starting with 261. Test number 2, question 61. And because I'm using Kindle, I have to adjust because I purchased the book to be able to use it on Kindle. I have to adjust the screen to preview. A homeowner goes bankrupt, her residence. In the foreclosure sale, the proceeds are insufficient to pay off the loan, and the court orders other properties sold to cover the shortfall. This action is called A, strict foreclosure, B, suit for specific performance, C, equity foreclosure judgment, or D, a deficiency judgment. So in other words, this person is default on their property, and it went into a foreclosure sale. So a lot of lenders are going to still want to have the remaining balance paid, especially in a foreclosure. If it was a short sale, it might be able to negotiate to write off the difference. So what do you think the answer is in this case? In the foreclosure sale, the proceeds are not enough to pay off the loan. So the court orders other property be sold, or for that borrower, right, to pay off the rest of the loan. A, strict foreclosure, suit for specific performance, equity foreclosure judgment, or D, default. The answer here is D, a deficiency judgment. Why? Because there's not enough money to pay off the loan. So there is a deficiency. So the property was worth less than what they owed on the loan. So 261D is the answer. And for those of you watching, you will be able to see the replay of the chat, but it takes 24 hours after we're done with the session, and you can see all the typed answers that I include. I verbalize them in the class. However, you can see all the answers that I typed 24 hours after the class ends. Could be a little bit longer. Okay, so whenever there are insufficient funds to retire a defaulted and foreclosed mortgage loan, a deficiency judgment may be ordered, if allowed by law, to make up the difference. To comply with the judgment, the borrower must raise additional funds from other sources to make up the difference between the outstanding loan balance and the proceeds from the foreclosure sale. Back in 2006 to 2012, there was a 2007 Mortgage Debt Relief Act that relieved homeowners on their private residence, on their homestead, to write off the lenders to write off the deficiency. Well, that expired. They extended it, and it expired this December. However, individuals can still try to negotiate with the lender or with the bank. Balance write-off, absolutely ask. And when you end up representing clients, when you become a realtor, most realtors don't like to deal with short sales. It's a lot of work. I did a lot of them. I was known as the short sale queen, so I helped a lot of people. Okay, number possession. The adverse possessor must satisfy which of the following criteria? A, the possession must have been concealed without permission and for a statutory period of time. B, The possession must have been unconcealed. In other words, it was open to everybody to know for the necessary length of time and without permission. C, the possession must be with intent, secretive, notorious, and hostile. D, the possession must be open without permission for the statutory period of time and within the number of permitted intervals. So which one do you think describes what an adverse possession is? So one clue, it cannot be secretive. Okay, it has to be open. Anybody can know that you're there, including the owners. Can't hide it if you want to ever take over that property. So by the fact that it's not secretive, then the answer is not C, right? Concealed. That leaves two answers left. What do you think that is? Is it B or is it D? Come on, y'all. Don't be shy. Type your answer in the chat so that I can help you should you not understand it and get it incorrect. It's okay to make a mistake, okay? So have I. So the answer is 262, B as in boy. The possession must have been unconcealed, not secretive, for the necessary length of time. Every state has their own statutory length of time that somebody must be occupying that land consecutively, not interrupted, has to be consecutively and without permission. So you could call them, a squatter. So, so the answer B. D is not because it says the possession must be opened within the number of permittables. It's continuous, okay? It continues on. It could be 10 years in some state. When I was in Oregon, it was 10 years. In Texas, I can't remember how many years it is. I haven't had to deal with that. But every state has their own amount of period. Statute of limitation. 63. One of the primary benefits of recording conveyances, what is a conveyance? Is to give evidence, what is evidence to the public, that the new owner actually owns the property. What is another benefit of recording to the homeowner? Okay, so recording a conveyance, what is it? Evidence, what is that? The benefit of recording. A, recording instrument establishes a title's marketability. B, recording the deed prevents any future clouds on title. What's a cloud on title? What is marketability? What is a title? C, recording prevents lien holder. Recording the deed of conveyances nullifies any and all claims of adverse possession. Conveying a title to another person, right? The seller to the buyer. So the primary benefit of recording is what? The answer for 63 is A. Recording instrument establishes the title's marketability. In other words, it belongs to the person that recorded it. Typically, the title companies, where a transaction goes to close, does the recording. It could be an attorney where the closing is done. So the fact that it's recorded, it can be marketable in the county records. That's where they get recorded, 263A. So when a property gets recorded, it's what gets recorded? The deed. Okay, the promissory note does not get recorded. Stamps and liens are recorded. The public is given notice of the property's indebtedness and encumbrances. What are encumbrances? liens, judgments, encroachments, clouds. And in turn, any future buyer can visualize what must be done to clear title and correctly and convey marketable title. They call it marketable title because it can be marketed to sell and it's legally owned by the current person that is shown in the deed. The title is their ownership of that property. If it has a lien, then the lien will be recorded and it'll say there's a vendor's lien. On the deed, it'll say the owner is so-and-so with a vendor's lien because there is a loan on it. Number 64. Right, I've got to move things around here a little bit so I can see it. I can see, there we go. 64. Broker Yvonne successfully closed on her listing, but the seller refused to pay the commission. Bummer. What is one legitimate course of action available to Yvonne? A vendor's lien. B, an intangible lien. C, a broker's lien. Or D, a mechanic's lien. These are all vocabulary, right? All these different types of liens. Those are vocabulary. So who hasn't been paid? The broker, right? Broker Yvonne. So then what's the legitimate course? What kind of lien will it be? Vendors, intangible, brokers, or mechanics lien? When you know the definition for all of those, you will know that the answer is 264 C as in Charlie, a broker's lien. The answer 264 is C, a broker's lien. Many states allow a broker in specified circumstances lien against a property following the closing of a transaction. Here, the party who is obligated to pay the broker commission refused to pay. The broker's lien, once filed, attaches to the real estate interest owned by the obligated party. So like when there's contractors that don't get paid, they put a mechanic's lien. When there are lenders, as I mentioned on the title, there's a vendor's lien. Intangible lien, that's a different type of lien. So in this case, it's a broker's lien. Now, in the only one reason the broker may not have gotten paid by this seller is because they maybe didn't have it in writing. So it's important to always have it in writing because the title company and the attorneys that do the closing as the escrow officers, they won't close anything until everybody gets paid. Okay, internet connection. Can all the screen, I know it goes in and out because I am seeing it myself. Please let me know that you can see it. Okay, number 65. One of the key characteristics of a short sale, is it a short sale because it's short in a few days, or is it something different to do with a loan? So one of the key characteristics of a short sale is that the transaction typically takes much longer to close. What is another anomaly of the short sale that makes it a unique conveyance alternative? A, the lender must approve the modified loan and selling terms. B, the real estate commission may intervene to protect the broker from seller default. C, the broker must take a discount on the conventional commission scale. Or D, the IRS must audit any loan modification. Money from the sale of the property to pay off the loan, and the lender accepts the loan that is owed. That is a short sale. And typically, yes, they do take a while. Sometimes they don't, but for the most part, they do. And it's a lot of paperwork and documentation that has to be provided by the homeowner. And typically, they can stay in the home until the lender approves a short sale and it closes. The lender will then pay the commission to the realtors and any repairs that must be done. And they're the ones that approve the offer. Plus, sometimes they do a cash for keys, meaning they want the owner to stay in the property so that it doesn't get vandalized, and they will get $1,500, $3,000 in order to help them move. Okay. Oh, I haven't typed the answer. So 265. Oh, I didn't say the answer. Is A, the lender must approve of the modified loan and selling terms. So they're actually approving an offer that was less than the amount that is owed with the realtors. And the realtor will ask, hey, it's time to reduce the list price. Are you okay with that? Or the lender might say, hey, reduce the list price. Let's get it sold. Foreclosures will also do that. They keep reducing the list price until they trigger an offer. At that point, the bank owns it. When it's a short sale, the homeowner owns the property. Okay, 265 was A. So let's say here, the conventional transaction principles are the buyer and the seller. In a short sale, the loan must typically be modified so that the parties can feasibly proceed with the sale. So the lender makes the final decision. The owner has to accept the contracts. They're the ones that sign them, but the lender makes the decision to accept the offer or not. Anytime the loan must be modified, the lender assumes a primary role in the negotiations and must in turn approve the loan modification made. And so in my experience when working with short sales, it's not that they modified the loan. When they do a loan modification, the owner keeps the property and the lender modifies the loan to hopefully provide a lower interest rate so they have a lower payment. And then they go through a trial period of paying several months to see if they can manage that new payment, and they get to keep the home. Any time that they default again, then they probably will pursue then a foreclosure. All right, chapter number 3, or national test number 3. So we completed the encumbrances, liens, title transfers, and recording leases and use and land. Okay, now we're going to do land use, legal descriptions, and contract law. Again, keep in mind, these are national questions. 3.1, which of the following is true regarding master planning and zoning? Restrictions. Okay. So A, the aggregate of zoning ordinances is the master plan. B, a master plan eliminates the need for zoning ordinances. C, master planning is a country level function. Zoning is limited to the city level. D, zoning ordinances are a primary means of keeping land use in harmony with the master plan. So which of the following is true regarding a master planning and zoning? So the master plan is a lot of times they do a 5-year plan for the whole city, including their rural areas. Then they have city zoning. County zoning is very limited. In other words, that's why a lot of people like to buy land out in the county and get their little ranch, a little farm, acreage. They can have animals. They have less restrictions. Anybody here? What is the answer to this? I'm going to type on here. We're on legal description law pertaining to national, not Texas. So this is test number 3. Okay, the answer here, nobody wants to participate today. The answer for 3.1 is D. Zoning ordinances are a primary means of keeping land use in harmony with the master plan. So as a city is growing, they have different type of zoning, right? For single residence, for duplexes, fourplexes, commercial, all this is within the city. And they do it in accordance to how the growth plan, the master plan of that city, that area is, to accommodate for, the structure, the infrastructure, all freeways, streets, bridges, lighting, curbs, water flow, power. It takes a lot of work. So the and zoning is D. Zoning ordinances are a primary means of keeping land use in harmony with the master plan. Because within the city, there's a higher density of homes. As go out, so in the central city, a single family, then they can allow for duplexes, triplexes, fourplexes, when you can have a little bit higher density. And then wherever there are apartments, hotels, commercial, it starts going a little bit out of the center of a town because they need a better infrastructure. So go and learn more about zoning. Legal description, contract law. The basic intent of zoning ordinances is to do what? A, establish the base. B, establish subdivision rules and regulations. C, specify usage for every parcel within the zoning authority's jurisdiction. Or D, restrict development in unincorporated areas. The city has to have the ability to grow and the infrastructure to support the growth of population, housing, businesses. So what do you think the answer here? The basic intent of zoning ordinances is to, the answer is 3.2C. Specify usage for every parcel within the zoning authority's jurisdiction. So in the center, going out, out, out. So they have zoning for every single parcel. As it goes out of the city boundary and goes to rural, then it becomes more acreage, right? Within the city, there are parcels that have, small lots, a quarter acre, half an acre, 1 acre. Going out into the rural county, you can have more acreage. That's for farm and ranch land. Okay, resorts and all that type of thing. But in the city, they have to really control the use of every parcel, specific usage for every parcel within the zoning authority jurisdiction. Moving right along, number 3. Any questions so far? I love it when you all participate, so it would be great if you would. Oh, gosh. Just bear with me here. I'm trying to make to support structures are available in the community. B, to separate land uses so that they do not interfere with each other. C, to preserve high density land uses. Or D, to discourage industrial and commercial users from relocating. So zoning authorities, right? Remember, they've got to control the density within certain areas because of the substructure, the infrastructure, to make sure that it supports the growth of a city. So why do zoning authorities of zones? A, B, C, or D? Come on, participate. Okay, the answer here is 3.3B, to separate land uses so that they do not interfere with each other. So if there is city zoning of residential next to commercial, a small business, not major commercial, because there's different levels of commercial, they'll have a buffer, an area between the two to separate and make sure that there's enough, there's no interference with each zone, residential with semi-commercial and that type of thing, so that you don't have issues with flooding and land, erosion and everything throughout the U.S. All right, so number 4. Number 4, any contract law. The key consideration in granting a zoning exception, known as a special exception, is which of the following? A, hardship. B, change of zone. C, the public interest. Or D, the use was legal prior to the new zone creation. Key consideration in granting a zoning exception. So the zoning has controlling is what? Who is it? Vis vida? D. Unfortunately, it is not D, but that's okay. The answer here is C. But thank you so much for participating. The answer for 3.4 is C. It is done for the public interest. The key consideration, especially, is which of the following? It is for the public interest. Excuse me. Let's say somebody wants to add an extra garage, or they want to change something, add a fence. They have to ask sometimes for a variance and inform the neighborhood who might be impacted by that. And so that becomes a zoning exception. It's affecting the public's interest. If there's no one that goes to the zoning board where they have the variance meeting, adjustment board, they let both parties speak. Anybody can go and speak. If there's no one against it, then the zoning department, the adjustment board, will approve it. But it is to make sure that it's kosher with the whole public and it's not impacting anybody negatively, like we had in the prior question, so that they don't interfere with each other. Okay, number 30, number 5, sorry, not 35, 3.5. Thank you very much for participating. That's awesome. But I wish I knew what your name is. It says vis vida. Thank you. The intensity of land usage generally refers to what? The intensity of land usage generally refers to what? The number of buildings, lots per acre. B, the number of people per square mile. C, the number of building permits issued per year within a zoning jurisdiction. Or D, the area of commercial or industrial facility in relation to the size of the site. So the intensity of land usage generally refers to what? So 3.5 D, 3.5D. So the intensity of land usage generally refers to what? The area of a commercial or industrial facility in relation to the size of the site. So let's see what the answer said. Commercial zoning regulates intensity of usage by limiting the area of store or office per site area. Intensity regulation is further achieved by minimum parking requirements, setbacks, and building height and restrictions. So any parcel that is going to build has setbacks, has to have space for parking, for building, what height, that it doesn't interfere with properties and blocking the view for anyone. So there are different types of restrictions, lots of restrictions. Now, zoning restrictions is the primary. Now, when developers go and businesses go and build subdivision, they create additional restrictions for their subdivision. For example, they want 4-bedroom homes with 3-car garages, large driveway, 2-story brick homes or stucco, sidewalks. Those are additional restrictions. And then they typically have to have an HOA to make sure that all that is enforced. Okay, any questions on national? That's it for national tonight. So I'm going to shift into Texas State. We just did questions for national. And if you have any questions, for later of what you would like for me to do, I go through these because it's important for you to practice questions, and the answers, and do them multiple times. I typically do the whole book with the questions and answers, and then redo them again. And so you might see some videos that have similar questions, but it's to make sure come natural to you when you get to the real exam. Now, they're not necessarily going to be those types of questions. Some of them might be. Sometimes students have seen the exact questions that are in the books in the real exam, but they're going to throw questions that have nothing to do with what you studied. They expect you to think, have common sense, and think about how would I solve this situation, or what would it take? We have to be problem solvers. Okay, so type any comments or questions while I shift to Texas State. So page 411. And if you have to buy the book, you can follow along with the book. Okay, 411. We're going to start with 15.5. All right. Think I'm ready. So we're going to end one test and then get into, so test 15 and then test 16. Okay, no questions. Okay, moving right along. So so on this test, we're dealing with, I think it's Texas contracts. Let's see here. So the end of test 15. Oh, that's not good. Okay, now you'll have to be patient with me to get this back on. Oh, now it says Kindle is not responding. It will, just bear with me. I was trying to show you what the test topic was. Okay, so I will show it to you in just a moment. So what, 411. Okay, so I was trying to show you that chapter 15 had to do with Texas contracts. Okay. I think there's one question left having to do with Texas contracts. The video, the class that I did, today is Tuesday, I think on Friday. Okay, number 15. During the course of a transaction where legal counsel should be consulted, in which of the following scenarios should the licensee recommend that the buyer obtain legal counsel? So keep in mind, whenever we give somebody a contract that we're completing, they want to sell their property and they want us to represent them, and they say, hey, can I take this to an attorney? Absolutely. It's a legal template. It's a contract. They're templates, and we fill in the blanks for the answers that they give us when we ask them questions per the template. Okay. But they can take it to an attorney so that they can explain it in detail, because we are not attorneys and that is not what we are allowed to do. Okay, so during the course of a transaction, the licensee must advise clients of various circumstances where legal counsel should be consulted. In which of the following scenarios should the licensee recommend that the buyer obtain legal counsel? A, the licensee is selling her own property and has just hired an attorney to represent her. B, a transaction involving several promulgated contracts. C, a contract for deed transaction involving several non-standard contingencies. Or D, a buyer is about to place an offer on a property where the previous residents had AIDS. So under which one of these can we recommend that they go to counsel? Because legal documents can be very confusing, and there are so many documents that we have to provide sellers and buyers to sign. So anybody take a chance and answer the question. Okay, so the answer to 15.5 is C, a contract for deed transaction involving several non-standard contingencies. So what is a contract for deed? That's not a normal offer with a lender involved. The contract for deed can also be called like a land contract, where it's between the seller and the buyer. And so here it says, in which the following scenario should the licensee. So in this one, it says, anytime there are unusual circumstances surrounding a transaction, which contract for deed is not a very common transaction that we normally, investors use them a lot. So the licensee is obligated to advise principals to consult legal counsel. So who's the principal? The seller or the buyer, right? Such an instance might include a contract for a deed where numerous special circumstances can be present. By contrast, licensees are not liable for even knowing about AIDS residents, much less consulting an attorney for such a reason. Selling one's own property is not an unusual circumstance. Okay, so we could be selling it kind of like owner finance. So we keep the deed, so we get a contract in exchange for a deed, and until that person ends up paying off the property to us as the seller. So if we're a realtor, we can sell our own property, okay? And we want to inform them and disclose, I am a realtor, I cannot represent you. I advise you to speak to an attorney or the attorney that we will be closing. And that attorney will charge both sides an escrow fee, but they can choose their own attorney. So look up contract for deed, look up promulgated contracts, transactions, whether you should disclose about AIDS or not, right? And there's matching questions, but we're not going to do those because it's a little bit challenging to do those going back and forth. I mean, we could. Well, let's try. Yeah, it's too much going back and forth to show you the different answers. That would be better if you have the book. 16. Which deals with special topics in Texas, since we are dealing right now with Texas test. Okay, number 16.1. Does it all show there? No. So has anyone here taken the exam yet? I would love to know. Okay, there we go. Has anyone here taken the exam yet? Or when are you getting ready to take it? Let me know. Post it on the chat. Okay, 16.1. Texas is a community property state. So effectively, this means that what? A, once married, all property in both estates is owned equally between husband and wife. B, upon legal marriage, all property becomes owned as tenancies in common. C, spouses, with some exceptions, share property acquired during the marriage, but not what each owned beforehand. Or D, all property acquired following marriage becomes jointly owned without exception. So community tenants by the entirety in other states, that's one of the forms of ownership. There's 4 different forms for residential property. So what do you know about community property state when it comes to the following? Once married, all property in both estates is owned equally between husband and wife. Is that true? B, upon legal marriage, all property becomes owned as tenancy in common. That's one of the other types of ownership, tenancies in common. C, spouses, with some exceptions, share property acquired during the marriage, but not what each owned beforehand. Or D, all property acquired following marriage becomes jointly owned without exception. Give me your answer. Type it in the chat. So 16.1 here. Nobody wants to answer. You're shy tonight. Okay, 16.1 is C. with some exceptions, share property acquired during the marriage, but not what each owned beforehand. Yes, very good. Super child of Christ. Oh, you should listen to my video that I created. I think it was Sunday night, where I say God, family, then real estate. I learned that at Keller Williams, and when I finally put God first in my life. Anyway, so thank you, super child of God, for answering. And yes, you are absolutely correct. So community property state, spouses with some exceptions share property acquired during the marriage, but not what each owned beforehand. If they own something beforehand and they want to add their spouse to the deed and have them have title ownership to it, that can be done. But there has to be a conveyance of deed from one person to the two of them. So it's similar. Whatever is purchased together, when tenants buy the entirety, has survivorship, which means when one spouse dies, what they own goes to the other spouse. In community property state, it depends. So it does belong to both of them, but it'll depend. With every state has their own laws. Number 2, a husband, hold on, I need to moisten my throat. Something cold to refresh my throat, moisten it. Okay, number 2. A husband in a community property state acquires a vacation property as a family gift on the first anniversary. What is the ownership status of the property? A, each spouse owns half of the property. B, the wife owns half of the property but must forfeit her share if she divorces. C, the property is shared since the conveyance was not via an inheritance. D, the husband owns 100% of the gift. Very important to know, gift. That's the trigger to knowing which answer is correct. It really doesn't matter whether it was in their first anniversary or at the beginning when they got married or years after. The key word, it was a family gift. So does that family gift belong to both or only to the person that it was gifted to? Very good, super child of Christ. The answer is 16.2D. That gift belongs to the spouse. If one of the persons is gifted money, motorcycle, a boat, it belongs to that one individual. That one individual can then share it with the other person. However, the day they divorce, it belongs to the person that received the gift. Unless they want to add their spouse's name to that gift, okay? Then it requires. Which of the following is not an accurate characteristic of homestead law? Do you know what homestead law is? If not, go study it. A, homestead rights require a one-time filing with the county clerk. B, homestead interest are extinguished if the property is sold. C, the family must occupy the residence to qualify for the homestead. Or D, homestead property can only be voluntarily conveyed by both spouses. So which of the following is not an accurate statement of homestead laws or accurate characteristic of homestead laws? Type your answer in the chat. The answer here is 16.3A. Homestead is automatically when it's your primary residence and we occupy it. Okay, it doesn't require a filing. However, it does require filling out a form to make sure you get the homestead exemption of reduced property taxes. Being that you're the owner and you're occupying the property, it's your homestead. However, if we don't fill out a form online or go to the county clerk, to the appraisal district and fill out the form that we want the homestead exemption, we don't get our property taxes reduced for it being our homestead. Once a person turns 65, they get additional property tax exemption. But homestead allows for a property tax reduction, a certain amount that each county has. So the fact that, so home time filing with the county clerk, it requires a filing of the homestead exemption to get the exemption, but not to get the homestead. The homestead is automatically. So homestead interests are extinguished when the property is sold. So when you sell your property, you no longer have a homestead on that. And we can only have one homestead throughout the US. So once we sell one, then the next home we own becomes our homestead. But again, we got to report it to the appraisal district to get the property tax reduction. The family must occupy, and that is a must. Pay attention to words like must, only, always, never. A lot of times they're trigger words for the wrong answer. And in this case, it wasn't. The family must occupy the residence to qualify for the homestead. D, homestead property can only voluntarily conveyed by both spouses. So if there is a couple, they're married, both of them have to sign the conveyance of the deed. If it's a single person, well, it's only one person signing, right? If they are tenants in common and it's their primary residence, then they both have to sign. They're not married, but they're tenants in common, and for each one of them, it's their homestead. Oops. All right, number 4. I messed up here. Number 4. Which of the following best describes a homestead tax exemption? Okay, I just mentioned that, right? A, an exemption from property taxation of portions of the homestead's assessed value. B, a direct reduction in the homestead property's tax by a certain percent. C, a homestead property is exempt from taxation. Or D, a homestead property's equity is exempt from taxation. So is the whole property taxes exempt, or is it a portion of it that's exempt? All governments want taxes, okay? So they're lenient with a portion. So the answer here for 16.4 is A, an exemption from property taxation of portions of the homestead's assessed value. I think in our county, it's now, they'll reduce the property assessed value by $140,000 and then charge taxes on the rest. So they just increased it. It used to be only like $40,000, which was not a lot because property taxes keep going up as an area grows and increases and there's new homes and improvements that impacts other properties. So 16.4 was A. All right, number 5. Oops. Oh. Well, not really. Which of the following is an accurate homestead exemption for county purposes? A, B, a 15,000 exemption for school districts. C, the standard homestead amount are granted to each family member resident. Or D, disabled persons can receive more than one residence homestead in a year. So where do you think they give us give homestead owners a reduction? Is it for county purposes or is it in districts? Oops, I don't think there's an answer of N. The answer here is 16.5 is B, a 15,000 exemption for school districts. There are lots of taxes for school districts, for high schools, for colleges, for school districts. Okay, number 16. Oh, come on. All right, number 16.6, right? Yes. Following the tax sale of a foreclosure proceeding, a homeowner can regain full ownership of the property by paying all amounts owed, plus fees and charges. In this scenario, which of the following is true? Fault because of property taxes. And so the property is being foreclosed by the county because of default of taxes. So, oops, sorry. So a homeowner can, following the tax, so a homeowner can regain full ownership of the property by paying all amounts owed plus fees and charges. In this scenario, which of the following is true? A, the homeowner may do this since he or she is exercising their equitable right of redemption. B, the homeowner may only exercise a statutory right of redemption prior to the tax sale. Or C, the homeowner may in fact, oops, I'm missing D, may in fact exercise the statutory right of redemption, provided the property is the principal residence. Sorry about that. I had them all on there and I lost D. Or D, the homeowner may exercise the statutory right of redemption, can trigger you to know that it's not the right answer. So a homeowner can get their property if it goes for tax sale, okay, in a foreclosure proceeding. But what is it that they have to do? Which of the following scenarios, A, B, C, or D? Well, D is not right, okay, because I laughed about it. So it's A, B, or C. The answer here for 16.6 is C. The homeowner may in fact exercise this statutory right of redemption, provided the property is their primary residence. Okay, so it's their homestead, it's their primary residence, then they can redeem it, okay, before the tax sale or at the tax courthouse sale. if an investor happens to buy it and pay for the property taxes, that investor, that new owner, will have to keep that property for 2 years without selling it. They can lease it, they can rent the house, sell it. The state of Texas allows the homeowner 2 years to redeem their property back by paying the taxes plus interest. For the first year, it's 25% interest on the balance that the investor paid at the tax sale. The second year, it's 50% of the balance owed. So the balance owed plus 50% interest. So there are investors that will buy really nice properties for property taxes. People lose great properties for just, they might owe $5,000 in property taxes or $10,000, and the property might be worth, $100,000, $200,000, $300,000. They'll lose it because of property taxes, or somebody passes away or illness or whatever, and they weren't on top of it. But they have 2 years to redeem it. Number 7, which of the following of internet? Okay, which of the following agreements are enforceable? A verbal 30-day month-to-month lease. B, an oral agreement to buy an oil interest in a property. C, a written lease signed by the landlord's son, an unauthorized representative. Or D, an oral property conveyance between a judge and a juror. So which of the following agreements are enforceable? A 30-day month-to-month lease, an oral agreement to buy an oil interest in a property, a written lease signed by the landlord's son, an unauthorized representative. Pay attention to that, unauthorized representative, an oral property conveyance between a judge and a juror. The answer here for 16.7 is A verbal 30-day month-to-month lease, because there are month-to-month leases. And so that can be enforced. If it's a year lease, it needs to be in writing. So whenever we represent an owner that owns property and is leasing them, the buyer and the buyer agent are going to request a copy of the leases. Therefore, if there aren't any because they did a handshake type of lease, we have to make sure that leases, they're called, or estoppel, it's a one-page document, or a lease is created so that both parties are aware of when it started and how much is paid monthly, whether insurance and utilities, all that. Both parties, meaning the seller and the buyer, because buyers wants to know. Investors buy rental properties, right? Because they want to get return on their investment. So 16.7 was A. All right, 16.8. To a landlord or a tenant. And every state has landlord-tenant laws. A tenant's right to vacate a week-to-week rental with at least 1 day's notice. B, a tenant's right to apply the security deposit to the last month's lease in an absence of damage. C, landlord's right to evict month-to-month lease tenant with 30 days advance notice. Or D, a landlord's right to waive liability for not maintaining habitability of premises. So which one do you believe is, okay, who said hello? Hey, Red Gal, how are you? Good to see you. Hello, I'm on in my online class as well. Awesome. Oh my gosh, you're multitasking. I should show comments. I forget. Oh, here. Show comments. Except they show real little. So thank you for joining us, Red Gal. Okay. You know, have people come in and participate, and we get to know each other a little bit. All right, 16.8. Okay, the answer here is you got to give a 30 days notice. 16.8 is C, landlord's right to evict a month-to-month lease tenant with 30 days advance notice. You would think that's only for a 1-year lease. However, you know, tenant needs to know, hey, I need you to go out. I need to get my property back, or tenant needs to let them know so that they can prepare to get somebody else. Because sometimes it takes a while to get the property occupied again. So which of the following is a legitimate power granted to a landlord or tenant 30 days advance notice? So on a year lease, it's common to have a 30 days notice. Some states now require 60 days notice. Email it, the lease agreement specifies. We do so much online now that better keep looking at your email, right? Or text messages. Number, a rental property. A, tenant may freely assign unit if leases for more than 5 years. B, tenant may assign or sublet, but must return property to original condition prior to the subtenant's occupancy. C, tenants are free to assign their lease obligation, but may not sublet without the landlord's permission. Or D, tenant must obtain landlord's prior consent to sublet the apartment. Disclosure, 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 right? Otherwise, it becomes squatters. 16.9, the answer is D. The tenant must obtain landlord's prior consent to sublease, like a sublease, and it'll show in the lease agreement whether they can lease an apartment or not. I'm trying to see here. Nope, that's not what I want to show. I'm trying to show the comments in a banner. Placement. Notes, people, private chat. Nope, banners. There's an example of a banner. Okay, sometimes I have the comment that shows throughout the bottom here, and I didn't set it up for such. Let me see here. Wide, no. Okay, never mind. I'll figure it out for next time. Number 10, any questions so far? No? All right, number 10. Which of the following is not a landlord justification for keeping a tenant's security deposit? A, to eliminate normal wear and tear to the apartment, including painting and carpet cleaning. B, to offset rent owed by vacating tenant. C, to repair damages to the plumbing system. Or D, to cover excessive damage caused by a dog, even though dogs are permitted. So which one is not a landlord justification for keeping a tenant's deposit? If you've ever rented, You probably know this without even studying it. So which one can they not do? Oh, okay, Red Girl. Hey, multitasking isn't usually very good. You can only learn one, but I appreciate you being here. Okay, the answer to number 10 is A. The landlord cannot keep deposit to eliminate normal wear and tear to the apartment, including painting and carpet cleaning. That's part of the owner's upkeep of their investment property that they make money on. Sometimes they lose, and but the goal is to make money from rentals. Okay, any questions? I'm trying to see here if I don't want to show headlines. I want to show. Okay, so that's it as far as Texas state questions. So we did 10 national questions, and then I think we did 10, yes, Texas state questions. And and there is a link in the description of the video should you wish to buy this book. I do get a slight affiliate commission from Amazon, but that doesn't cost you any extra. And then here's a little bit of, so this book, the cover introduction over courses for Texas and for other states. So it has all the National Law Review, real estate math cramp cards. I do very little math unless students ask me. Texas laws and regulations, national practice test, then the Texas state level practice test. There are 6 tests, and then there's a complete Texas license examination, which is like a full-blown exam as if you were going to take it on the exam day. The answer book does not have vocabulary. Some of the prior books that I have purchased had vocabulary. This one does not. However, you can find vocabulary. Any questions before we call it a night? I greatly appreciate all of you staying on here. I enjoy doing this. I've been doing them since 2014, but on YouTube only since 2020. I have lots of playlists that have national, Texas state questions, a combination of both. Some are pre-recorded. Most of them are live, and then vocabulary also, and then some concepts. I'm also creating videos for what do you do when you get your license and you start practicing real estate, listing presentations, how to deal with buyers, sellers. I'll be creating more videos. It takes a little bit of time. So my goal is to try and do 3 to 4 videos a week, go live several times a week so that you can practice your questions. I will also do some on vocabulary. And I am an active realtor here in San Antonio. I had a license in Oregon when I was over there. Prior to that, I was an engineer, electrical engineer. So I'm detail oriented, no nonsense, to the point, very direct. I'm a driver personality. If you ever take personality tests, there's the DISC, there's the dominant, the influential, the compliant, and the social person, DISC. I'm a dominant driver, and I converted from a DC, driver compliant, to driver influential. I have to work on that and be softer in more gentler sometimes with people. And I love to help people. That's not an issue. I enjoy that, but sometimes I'm very direct and to the point. Okay, questions before we call it a night. Hopefully tomorrow. Oh, let's see. Did somebody post something on here? Oops, sorry. Yay, you got it right. Awesome, Red Gal. All right, keep going to your class, do your other class, and the rest of you create a schedule to prepare for your exams, to study. Study every day. Create a schedule, put it on your calendar, relax. Sometimes I like to have music on the background or a diffuser, to have a nice scent. Usually I have it on. I haven't lately. I was going to show it to you. I have a diffuser like this that I put lavender or lemon or something to energize, depending on what mood I want, to help you focus. Do whatever you need to help you focus and prepare. Repeat, repeat, repeat. Take those quizzes, those tests until you score 100. 70 is not good enough. 80 is not good enough. The actual exam is much harder. Okay, well, next time, hopefully tomorrow night, Wednesday. Thanks for being here. Love y'all and wish you the best if you're taking your exam tomorrow or any day real soon.